So if everybody is on the same page, so Felicity, the floor is
Hi.
yours.
Thank you, Michael. Well, the case I dealt with, when we got to court, it didn't take very long because we had spent an awful lot of time thinking about how to do it in advance. And when my client came to me, it wasn't obvious how you go about getting the court order that Apple wanted us to get. Apple seemed to presume that there was a straightforward mechanism for doing that, sort of like, for those who are familiar with it, the Norwich Pharmacal jurisdiction, by which you can get, for example, an internet service provider to give you the name of who owns a particular email address or online account, which has a specific provision initiated by case law and now supported in the civil procedure rules, where you can do it quite straightforwardly. And there isn't such a system for this type of order. And we had to sort of invent one. And it's not straightforward. As everyone has said, there are a whole host of issues in the background that we didn't in the end need to go into exploring, but about property. Is this actually property? About rights, whose rights are these? And in our case, it was relatively straightforward factual scenario in that Mrs. Thompson, who was a widow, was the sole executrix of the will and the sole beneficiary. So there wasn't a lot of competing people floating around in terms of who might have legal rights here. Although, of course, there are potentially other people who may have been in those photographs and videos that were in the iCloud who may say they have personal data rights. And one suspects that may be what Apple was worried about, because you think, well, who are they scared about being sued by? Why are they so insistent upon a court order? What's their fear here? Their client is dead, he can't sue them. So that is my suspicion. And it was interesting because Apple told us that county courts are granting these sorts of orders. And I suspect it's a case of, although there are all sorts of thorny issues that one could raise in the background, the right answer is fairly obvious to the court. The court is being told that I can do this and therefore they do it. But it doesn't resolve all those underlying issues which aren't straightforward and which I think it would be helpful if there was a procedural route, but I think the issues are broader than procedure. How actually should the law deal with this sort of scenario? And Lillian raised some interesting points in her introductory remarks about the terms and conditions, and it was something I did consider. They are extremely onerous, and I bet almost no one knows that that's what Apple, and it's not just Apple, I'm saying Apple because they happen to be the defendant in this case, the respondent really, they didn't fight it, but I expect lots of people don't know what they're signing up for. And I think we need to take a more general approach. It's quite difficult to rely upon grieving heirs to have to go and get a court order that it is not obvious how you get, that it is, because it's not obvious how you get it, it's inevitably going to cost some money. Well, it's going to cost some money anyway, but it's going to cost more money than if there was a straightforward route. I don't think that's a satisfactory way as a society of us dealing with these issues. And it doesn't, or it might, in a different case, end up with quite a difficult balance for the court to strike, because if somebody were to come and say, well, you know, in Mr. X's case, well, I definitely know that I'm in those photographs and I don't want those to be revealed to Mr. X's heirs, what does the court do about that?
Thank you, Felicity. I would note, kind of, you know, when we looked into the cases, like many of us here in the room, and searched, there are very few cases globally that have reached a judicial decision. There are many compromises, or at least reported, which we learn about anecdotally from, you know, newspaper reports, etc. But real cases, we have what, 3 or 4 American cases and the German case, and maybe something else, but that's it for the time being, and that's interesting in itself.
I agree. When I was researching this, I was extremely surprised that no one had to deal with this before. It feels like the sort of thing that must have happened before. We've all had digital lives for quite a long time now. Right. I suspect the answer is that some people can do what you're told not to. Some people know their partner's password or can get through the security questions. Some people have other means of storage, and so you lose a few things, but the rest of it's stored on the family computer, so they don't bother. Or some people, I suspect a lot of people, look at it and go, there's no obvious way to do this. They go to the high street lawyer who says, not a clue, and they give up. But it is surprising. It's surprising when you see the compromises. Sometimes they'll compromise if you pick up enough fuss and sometimes they won't. It leaves you in the unattractive position of, you know, potentially ringing up the Sun news desk or whatever and posing as the grieving widow or grieving son and going, isn't this awful, in the hope that Apple will pick up that the bad publicity is not worth it to them.
Right.
Which again is not a satisfactory response.
Sure. I would add to those optional answers for the, you know, for why we have so few cases. The platforms are repeat players and they have no interest in reaching high courts unless they're pretty sure that this will be on their side. So they do rather settle, like in many other cases of, you know, big corporations and small consumers or citizens or what have you.
I completely agree with that. And I have thought that if you had a client with this sort of problem who had an awful lot of money and the will to fight the case, which is often how these developments happen. It's how privacy law really was established in England and Wales, was that some very wealthy people like Naomi Campbell and Max Mosley decided to have a fight. If you had somebody like that, you could raise some really, really uncomfortable issues for the platforms, uncomfortable issues about the fairness of their contract terms, uncomfortable issues about the rights of the individuals whose data they're storing, whether you look at it through a rights lens, a privacy lens, a property lens, a succession lens, you could raise all sorts of uncomfortable questions. And I do wonder if they would want to take that all the way to the Supreme Court, which might be where it was going if you ended up in this fight.
Sure. So thank you, Felicity.